So, a claim for increase. The name, I guess, implies that there was a preceding claim. So when might a veteran consider a claim for increase?
The way the system works, once you apply for benefits, the VA issues a rating decision, assuming that the rating decision is favorable in the sense that service connection for a particular condition is granted, whether it's for your back or for PTSD or for an injury to your hand or whatever it may be. Once that condition is granted, the VA in that decision will set what they call a rating.
Welcome to the Victory Over VA podcast, a podcast about empowering veterans to overcome denied disability claims. Each week, we deliver critical insights to help you understand the disability process, veterans' benefits, and how to take control of your legal rights. Now here's your host, Attorney Francis Jackson.
Welcome to Victory Over VA, your guide to unlocking veterans' disability benefits. If you're a veteran applying for benefits, be sure to subscribe to our podcast for the latest developments in VA disability. I'm Francis Jackson, this is Kristian Terison, and we're attorneys at Jackson and MacNichol, where we've helped thousands of veterans to win millions of dollars in benefits. We created this podcast as a resource for veterans who are applying for disability benefits. But it's not just for veterans. It's also for anyone with an interest in veterans' disability issues, whether you're family members, community members, or anyone else who just wants to understand more about disability benefits and help to get justice for our veterans. Today's show is about claims for increase. And with that said, let's launch.
All right, so a claim for increase. The name, I guess, implies that there was a preceding claim. So when might a veteran consider a claim for increase?
Sure. The way the system works, once you apply for benefits, the VA issues a rating decision, assuming that the rating decision is favorable in the sense that service connection for a particular condition is granted, whether it's for your back or for PTSD or for an injury to your hand or whatever it may be. Once that condition is granted, the VA in that decision will set what they call a rating. That is to say, they will determine the severity of the claim, and based on their internal rating criteria, they will set a percentage, and that percentage can range anywhere from 0 to 100. But once that percentage is set in that rating decision, that percentage continues with you forward until there's some change. And the way it typically gets changed is by filing a claim for an increase in the severity of the claim, which you believe justifies an increase in the rating level and a higher percentage.
Okay. Now, for illustrative purposes, what are some examples of conditions and how the symptoms might advance that would justify a claim for increase?
Sure. Well, let's take the most basic possible example. A veteran served in Vietnam, was exposed to Agent Orange, and now has hypertension. His or her hypertension is at a low enough level in terms of the systolic and diastolic blood pressures that the VA agrees that it should be service-connected based on the exposure to Agent Orange, but says that the readings, the systolic and diastolic blood pressure readings are low enough that it doesn't qualify as a compensable rating, and so they assign it with a 0%. 5 years later, the veteran is older, the arteries are hardening, the weight is increasing, all those things that tend to boost hypertension, and now the hypertension readings are higher. So we're past the 1 year where that initial rating could be appealed. So it's too late to proceed that way. So the step that is next is to file a new claim for an increased rating for hypertension. And it would be fairly straightforward. You would get the current blood pressure readings from the treating physician or treating nurse practitioner or whoever is tracking the treatment for your blood pressure, and submit those to the VA with a claim for an increase and ask them to award a higher rating. And again, it will depend on how the hypertension readings, the systolic and diastolic blood pressure readings, relate to the VA's listings for severity. But they could raise it to 10%, 20%. It simply depends on the facts of the particular case, but that's the way it works.
And I think your example provides a good moment to talk about the difference between a claim for increase versus a claim for another condition with secondary service connection. Because,
Sure.
There are a number of conditions that develop because of chronic hypertension. And so if a veteran develops one of those, would they still file the supplemental claim?
Well, assuming that there's a secondary condition caused by a primary service-related condition, one that seems to crop up an awful lot among our older Vietnam veteran population is they will have been exposed in Vietnam to Agent Orange, and they'll have diabetes. And out of that will flow a variety of potential complications, but one of the most common seems to be neuropathy in the feet. And so if you were past the 1-year period to appeal from the original decision, then it's necessary to pursue the neuropathy as a separate claim. And generally speaking, the most straightforward way to do that would be to file a new claim saying, I have diabetes, now I have neuropathy in my feet. That is a secondary condition caused by my diabetes. Here's a nice letter from my doctor saying that diabetes has now caused neuropathy in the feet. VA, please look at this and rate my condition.
And you talked about the importance of having medical records to substantiate the worsening of the condition. Are there any other records or any other types of documentation beyond the treatment records that veterans should gather when making this type of claim?
Well, claims for increase are actually among the most straightforward in the VA system because you've already gotten over what is typically the biggest hurdle, which is service connection for the disease. But secondary conditions get a little more complicated. When you're talking about a secondary condition, the primary thing that the VA is going to be looking at is, can you show that this secondary condition in fact stems from whatever you're saying is the primary condition? In my example, we were talking about diabetes and neuropathy of the feet. So the information that you need to supply to the VA is kind of in two parts. One is the information showing that there's now neuropathy in the feet. That's basic. The kind of second level piece of information is you want, if possible, to get medical evidence that there's not some other separate cause that is leading to this condition that you're saying is secondary to your service-connected condition. So if possible, and it won't always be possible, but if possible, you want to get a nice letter from whoever the treating medical person is saying, and by the way, we've looked at other things that can cause neuropathy of the feet, and we've been able to exclude all of those conditions. It is clearly from the diabetes. Or at least a letter that says, well, there are other conditions that can cause this problem. We've looked at them, but it is at least as likely as not that the diabetes is the cause of the current neuropathy. It is secondary to the diabetes, and please grant Mr. Jones's claim for neuropathy as a secondary service connection.
Okay. And just to emphasize that at least as likely as not language is a big one when dealing with medical providers, because the human body is a complex set of interrelated systems. Pulling one cause out from among other competing causes is something that a lot of doctors are hesitant to do, but many will say, it will be comfortable saying, well, it's a 50-50. And that at least as likely as not is all that's needed to prevail. Is that correct?
That is correct. And you make a good point that doctors tend to come from a scientific background. They tend to look at causation as resulting from multiple factors. And so I just want to underline what you said because it's really important. They often are not comfortable saying A caused B. They are more likely comfortable saying a constellation of factors may be the cause of B, and one of those is A. But as long as you can get them to say that causation from the service-connected condition is as likely the cause of the secondary condition as other possibilities, then that's sufficient. And that's really important. I'm glad you brought it up.
Yeah, I'll never forget, I had a COPD case where I was going back and forth with the pulmonologist, and they just kept balking and kept balking. This veteran was a Navy vet, and he'd been on boats in the 1960s, late 60s, early 70s, asbestos everywhere, but he was also a smoker. And I had a breakthrough moment, finally, with the pulmonologist. I got him on the phone, and they're saying, I can't write a letter that the asbestos caused the COPD and da-da-da-da-da. And I said, well, what did cause it? And they said, well, it was either the asbestos or the cigarettes. And I said, 50-50? And they said, well, yeah, there's no way to know. And I said, would you put that in a letter? Oh, yeah, I'll put that in a letter. And we won the case.
And that's how this works. Just as an aside, this standard, this at least as likely as not standard, is the kind of lowest standard of proof required anywhere in the American legal system that I'm aware of. In most instances where you're involved in legal matters, the proof has to be at least by a preponderance. It is more likely than not. In some cases, as you know, it has to be higher than that. But in most cases, it's at least as likely as the standard here, at least as likely as not, is lower than the typical standard of it's got to be more likely than not. And it's very hard, and you really put your finger on it, it's very hard in a lot of cases to get doctors to understand this standard because most of them, to the extent they've dealt with legal issues at all, have been inculcated to believe that the standard is always, I've got to say it, this caused this, it's more probable than not, there is a reasonable medical probability that, and none of that's required here. All they have to say is, it is at least as likely as not that this factor out of 2 or 4 or however many factors there may be is the cause.
Yeah. And I've found in the cases I've handled that even doctors who work at VA facilities are just as unfamiliar with the evidentiary standard as doctors who are, their only interaction with the legal system is Social Security, workers' comp, things like that. So even if you're dealing with a VA medical provider, don't assume that they're going to understand the at least as likely as not standard.
Yeah, and I can't tell you the number of VA compensation and pension exams I've seen where the examiner rejects the notion that the condition is connected to service based on the proposition that the medical evidence doesn't clearly prove that it's caused by service. Well, it doesn't have to. It just has to show it's at least as likely as not. But so many doctors just do not understand that and can be critical in these claims for increase just as it is in the typical claim for service connection.
Right, and any other claim, honestly, in the VA disability system. So if a veteran makes a claim for increase and it's denied by the VA, what are the options available to them?
Well, basically you have the same options as any other denial. Assuming this is an initial claim for increase, haven't been any other decisions about it, the 3 claim possibilities that exist under the AMA statutes that we are dealing with currently would be a higher level review, supplemental claim, or an appeal to the Board of Veterans' Appeals. And let me just touch on each of those quickly. Higher level review simply takes the existing evidence, submits that to a senior claims examiner in the same regional office where your claim just got turned down. Generally speaking, our experience has been that that's not a very useful process, that the claims examiner who's looking at it the second time will typically say the claims examiner who looked at it the first time got it right. That's not always true. I mean, sometimes there are errors that are pretty straightforward and will be picked up on higher level review. And I mention that because higher level review is the fastest way to get a claim reviewed. Unfortunately, it's the least effective. But the second alternative is filing what VA calls a supplemental claim. Supplemental claims are essentially an opportunity to give the VA more evidence about the claim. In fact, when you file a supplemental claim, one of the requirements is that you must submit additional evidence. But the point is, on higher level review, there is no additional evidence. On supplemental claim, you can look at why the VA turned down the claim and give them more information about that part that they have said is a problem. Whether it's the medical evidence, whether it's the factual evidence, whatever it is, you can give them more evidence to support that part of the claim. And those claims have at least a higher probability of success than higher level review. It's still no panacea, but they're better. And finally, there's an appeal to the Board of Veterans' Appeals. Those appeals really should be reserved for kind of the big issues. And by that I mean claims where there is a substantial amount of benefits at stake. And the reason for that is that presentations to the Board of Veterans' Appeals really need to be a full-bore presentation, good medical evidence, typically an expert opinion. If it's a vocational issue, typically, again, an expert opinion. They're not cheap, and they take time. The board is running for claims that don't fall into any of the narrow exceptions to be expedited about 3 to 4 years, sometimes more than 4 years. And even after everything is submitted and a hearing is held or there's a submission in lieu of hearing, it can take another year or two to get a decision. So it's not a light choice to go to the board. But the board, partly because this is an opportunity for a real full-bore presentation, and partly because you're dealing with much more sophisticated people at the board level. Lots of judges have years of experience. They're trained attorneys. They have a support team of trained attorneys. So our experience has been that the most probable place for success on a difficult claim is at the board. But as I mentioned earlier, higher level review and supplemental claims are much faster. So if it's a claim that might work on higher level review or it might work on supplemental claim, there's probably a good argument for trying those first, and if unsuccessful, then going to the board.
Okay. We're just about out of time for today, but I guess in conclusion, if you could just speak to, are there any common mistakes veterans making when it comes to claims for increase, and also what can be done to avoid those?
Sure. I think the most common mistake that veterans make on claims for an increase is assuming that the VA is just going to take their word for it. Mm-hmm. You know, they write a nice letter to the VA saying, my problems with my left knee have gotten worse, please give me a higher rating. In all probability, that's not going to do it. The best you can hope for with that kind of presentation is that A, the VA will send you out for a compensation and pension exam, mm-hmm. and B, the compensation and pension examiner will actually have the time and take the time to read your records, mm-hmm. do a thorough exam, and submit a favorable report. Mm-hmm. The odds are not high on those things happening.
Especially if you've got flare-ups or repetitive use problems, things that aren't there all the time.
Right, things that are not easily observable. Mm-hmm. Yep. So my advice is to make sure that you provide the medical evidence explaining how it is that your condition, whether it's the knee or something else, should meet the criteria for a higher level rating with the VA. Unfortunately, lots of veterans are not particularly sophisticated folks. They don't have the expertise to comb through the federal regulations and the medical experience to understand what the rating criteria require in terms of medical evidence.
For that matter.
Sadly, that's true. The folks who do this tend to be pretty specialized, but it's just unfortunate that just submitting a claim saying my knee's worse and I deserve a higher rating is probably not going to be enough. You really need good supporting evidence.
All right. And on that note, thank you so much for joining us this week on Victory Over VA. Please be sure to subscribe and join us here each week where we have the latest updates on trends in law and veterans' disability matters.
And we hope to see you next week.
Thanks for joining us this week on the Victory Over VA podcast. Make sure to visit our website, veteransbenefits.com/podcast, where you can subscribe to the show in iTunes, Spotify, or via RSS, so you'll never miss a show. While you're at it, if you found value in this show, we'd appreciate a rating on iTunes, or if you'd simply tell a friend about the show, that would help us out too. If you like this show, you might want to check out our free consultation to see how we can help you with your denied claim. Simply go to veteransbenefits.com and fill out the form. You fought for us. Now let us fight for you. And be sure to tune in next week for our next episode.